Hello everyone, and welcome to our lecture recording for chapter 8, and we'll continue with our discussion on the substantive area of contracts. And today we're going to look at one of the elements that we discussed in the previous chapter, which is agreement between the parties. So our first objective for today, the chapter objectives are of course on page 205, and we started the first out of 5 that asks us to identify and explain the requirements for a legally binding agreement. So these are the requirements for an agreement, but this agreement is legally binding. Okay. So the discussion is on page 206, and as we said previously, unless the parties are in agreement, a contract cannot come into existence. So this is the first element of 3 elements that we need to establish in order for us to assert whether a contract exists or not. We're talking of course about simple contracts. And as a refresher, we said these 3 elements are agreement, intention, and consideration. So the first one we're going to talk about today is this idea of agreement. And under what's known as the traditional approach, we have to establish that there is an offer and acceptance with 2 parties as a minimum. There could be more, and there has to be something that we refer to as consensus ad idem. Okay, this is the idea that an exact correlation between the 2 sides of the agreement exists. So the parties basically must have exactly the same thing in mind in order for us to establish that there is in fact an agreement. And as we said, there has to be an offer by one party to be bound on certain terms, and an unqualified acceptance that the offer, an unqualified acceptance of the offer by the other party. Now there are alternative ways of coming into an agreement. So what we have just talked about is what's known as the traditional approach, which is on page 206. However, there are also other approaches where there is more complex matrix of facts or more complex situations, and these are talked or discussed on page 207 under situations where it's difficult to locate an offer or acceptance. So examples include things like transportation of passengers on mass public transport, or competitions in a regatta, and things like exchange of contracts to sell land. On page 206 you'll find that there's figure 8.1 that gives us this explanation of how an agreement could happen. Okay, an agreement between 2 or more parties could either be through this traditional approach of an offer or an acceptance, or rather offer and acceptance, or it could be through conduct. And this other possibility of conduct is what we talk about, where there are situations where it's difficult to locate the offer or acceptance. Okay. Under the traditional approach, we said that there has to be an offer and acceptance, and that the offer and the acceptance have to match. So this consensus ad idem, and the idea that you are offering something on specific of certain terms, and the acceptance is an unqualified acceptance of those certain terms. Okay. So going back then, this idea that you can do or you can arrive at an agreement without really ascertaining the offer and acceptance, the traditional approach. We said these exceptions to that traditional approach look at really the conduct of the parties, so things like transportation of passengers on mass public transport, or competitions in a regatta, or the exchange of contracts to sell land are exceptions to this idea of having to find offer and acceptance before we can ascertain that there is an agreement. Okay. In these exceptions, in this other approach, it says, as it says on the bottom of page 207, the question is whether the facts when viewed as a whole and objectively in light of the surrounding circumstances, show that from the point of view of reasonable persons on both sides, A, conclude the agreement has been reached. Okay, that's the key point, that you are looking at the conduct of the parties and the factual matrix to ascertain whether there has in fact been an agreement. There are also 2 points on the fact that contracts may be inferred, so you can infer the existence of a contract, or the fact that essential terms must have been agreed upon, which is the point made in the Azizi case that you see on page 208. Okay. There's also further discussion of contracts or other agreements arising from conduct, as you see on page 209. So while offer acceptance are the general rule, it says clearly expressed in agreement, it's still possible for an agreement to arise by way of implication, okay, as a result of the conduct of the parties. And examples of that are given to you in the Clark and Earl of Dunraven and Mount Earl, the Satania, again on page 209, and the Raguse and Sullivan case that's discussed further in the textbook beyond page 209. So this part explains what each of case presented in terms of difficulties to finding the offer acceptance, and how the court then substituted that traditional approach with being able to find agreement from the conduct of the parties. Okay. All right. There's also a discussion of the Brambles Holdings case on page 210. There was again an offer there, but the issue for the court related to the question of whether there was acceptance by conduct. So sometimes it's only part of the situation that is not actually clear on the traditional approach, but you can still substitute it by looking at the factual matrix and looking at the conduct of the parties. All right. Let's then continue with the first step. It says an agreement may not necessarily be the contract. So sometimes you could have still an agreement, but it's not enough for you to find a contract. It is the act of assent which gives rise to the agreement. So the idea that you have agreed to something that's promised by someone else, and that they agreed to what you have promised in return, which is what we call consideration. Basically the idea that you have bought their promise with a price, that's what we call consideration, and that's later on we'll be discussing that in much more detail as the third element that needs to be established in a simple contract for its existence. Now note that agreements, in order for them to be legally binding and to be upheld by the court, they do not have to have much detail, as long as it can be said that a reasonable person, again the reasonable person test, would believe that an offer had been made or that the parties had reached an agreement. So this is an objective standard because it relates to the reasonable person. Alternative would be what we call a subjective standard, which means that you look at what was happening in the mind of the person that's being tested, so whether it is the plaintiff or the defendant. But the idea is that that subjective standard looks at what that person had in mind at that point in time or during those circumstances. Now a key point in relation to finding agreement is that there's a presumption that there's equal bargaining power between the parties to the agreement. So assuming that both parties can actually bargain for whatever is best for them, the optimal position for them, and then they could achieve that through agreement through this bargaining process. Sometimes of course that's not necessarily true in relation, for example, to someone who's a consumer that's bargaining with a huge corporation, for example. All right. Or sometimes because there's pressure, where there's pressure used by a stronger party, that makes, of course, this unconscionable behavior, an unconscionable agreement, and the contract would be set aside. Okay, So there is actually the possibility that you wouldn't actually have to perform your part of that contract because the way that the agreement was obtained was unconscionable, so basically unfair in that sense. Okay. Now sometimes even non-contractual agreements may also result in breach of the Australian consumer law, and we'll talk about this consumer law in some more details in later chapters. But keep this point in mind that sometimes even if it's non-contractual agreement, because it's imposed on you by law, so this is sometimes what we also call as quasi-contracts, but even though there was no agreement, there would be a non-contractual agreement, so it's not something that you have bargained for. Okay. A non-contractual agreement may also result in breach of the ACL under sections like section 18, which is misleading conduct, and section 29. We'll talk more about these when we get there. All right. We said the point about this agreement arising from conduct, and that's on page 209. Okay, and we looked at some examples that give us an idea of how that works. As I said, the tutorials or the colloquies are where we talk more about these examples and then follow through with the tutorials to even elucidate more the concepts that were studied in the lectures. Alright, let's move on then to our second objective that asks us to describe the rules that distinguish an intention to be bound to an offer. So this is basically what we refer to as the rules of offer that come under the traditional approach, or what's known as the convention approach, as described as a convention approach on page 211. Now there's an in brief box there on page 211 that gives you really all these rules in a nutshell. So it says in determining whether there is a valid offer or something else like invitation to trade, which wouldn't qualify to be to bring about an agreement, and hence there wouldn't be a contract yet. So things like invitation to trade, inquiries, supply of information which cannot be accepted, all of these things are not offers, and hence wouldn't lead to an agreement or to a contract. So we have to ask ourselves whether there was an intention or willingness to be bound. So if there's no intention to be bound, there wouldn't be an offer. Okay, there has to be a firm promise, a communication of the offer, okay, preferably in writing if the transaction is important to the parties, but can also be oral or by conduct. And in addition, so these are the main three things that you need: to intention, to be willing to be bound, and remember that this is actually a separate element that comes later on under the existence of a contract when we look at the intention to be legally bound between the parties. But it also comes through as something that's relevant to whether there is an offer or not. So there has to be a firm promise. So you are promising something specific. So let's take an example of offering someone a pen for $10. Okay, so your promise to this person is that you're going to sell them the pen. This has to be a firm promise in the sense that we know which pen we're talking about. The other party knows exactly what pen we're talking about, the description of that pen, and maybe even things to the relation of when it's going to be delivered and how much you want for it. Definitely how much you want for it in terms of price, and sometimes of course also how that price is going to be paid. Okay, is it going to be paid up front or is it going to be paid with finance and so on. You have to communicate, of course, this offer to the other person, otherwise they wouldn't know that there's an offer. And in addition to these three rules, we also have the following four rules. So this is all on page 211 in the brief box. They may be made to one person, offers may be made to one person, or they may be made to a group of persons, or offers may be made to the world at large. As we said, for example, under a unilateral contract, if you lose a pet, A lost Fluffy, so they put something in the newspaper, that local newspaper, say, if you find this pet, I will give you that much. Okay, so this is an offer that's being communicated to the world at large. Or offers may be kept open. Okay, may be kept open if supported by consideration. So you might actually say to someone, look, I want to buy this pen for $10, but I don't have that money right now. How about I'll give you something like maybe $1, say, or 50 cents, and you keep this offer open for me until tomorrow, because by tomorrow hopefully I'll have the money, and then I'll, you know, figure out basically whether I want to buy the pen or not. So you can buy that option of keeping the offer open for you, but it has to be with consideration. You have to pay for it. You know, you don't just say, promise me that, you know, you just keep this pen for me, I'll come back tomorrow, and then you come back tomorrow, you find out that they have sold that pen already. That wouldn't work legally. You have to actually pay something for that option to keep the offer open. So if you say to someone, you know, promise me that you keep this pen until I come back tomorrow, and they say, yeah, sure, why not? That's not really legally binding on them. Okay, what you have to do is to actually say, okay, and in consideration of that promise of yours to keep this offer open, basically to keep the pen for me until I come back tomorrow, I will pay you this much. So then this would be sort of some sort of a collateral contract where you gave that person money in order for them to keep this pen for you until you come back. Of course, for them, it's much better to sell it to someone who already have the $10. Okay, who already has the $10, and they could just simply buy the pen. But if you buy from them this option, it's even better, because now they can sell the pen not just for the $10, but $10 plus how much whatever you've considered for the your consideration for the option. So it could be for $11 or $10.50 or whatever you have paid for that option. So that's what they're thinking about, and that would be, of course, for them economically more reasonable. Okay, but the key point is that going back to our rules on page 211, it says that they may be kept, i.e. the option may be kept open for you to buy the pen. The offer is kept open for you to buy the pen if supported by consideration. So if you pay for that option to keep that offer open for you to buy the pen. If not, then of course it wouldn't be legally binding on the person. They can sell the pen to whomever comes first and buys it. Then there's the rule that all terms of this offer, all terms of the offer must be brought to the notice of the offeree. The offeree is the guy or the person who receives the offer. The offeror is the person who makes the offer, and the offeree is the person who receives the offer. Okay, so all terms must be brought to the notice of the offeree and followed exactly. Okay, and they also may be terminated. So an offer may be terminated, and that's our third objective when we look at how we can terminate an offer. Then you'll find also I'll also refer you actually to something on page 552 in relation to the issue of shares. The issue of shares, you might have something, you might want to have a look at that as well. And as far as also referring to La Forest on page 721. Okay. Now, page 211 continues to ask the question, what is the meaning of offer? Okay. And you'll find that it says, second paragraph, what makes a statement an offer depends on what the parties had in mind at the time of that statement. So in many disputes, this will be impossible to determine. Okay, so what we have to do instead, the course will rely on something called the reasonable person test or the objective test. That is, the test is would. So you will find that all legal tests come in question marks in a question sort of format. So for the reasonable person test, in this circumstance, we'll ask, would a reasonable person have thought that the offer was made with the intention of the person making it being bound as soon as it was accepted by the person to whom it was addressed? Okay. Okay. All right. So a key point that we want to emphasize comes on page 212. We talked about the communication of an offer, and there's the most important thing probably is also the business tip on page 212. It says put the offer in writing if it's important. So as business students, as you go through this course, as you go through these lectures and the textbook, it's very important to read these business steps, because that's basically your takeaway or take home point. So it says if the proposed contract is important, then put the offer in writing for the purposes of certainty and reducing potential exposure to expensive litigation. The terms of the offer must be clear enough for the offeree to be able to decide whether to accept or reject the offer, and should include at least the following. First, identification of the parties, identification of the subject matter and quantity if it is goods, consideration, usually in dollars, to be paid how, when, and where, and time of performance and method of performance. Okay, so this is what you need to be very clear about. If you are making an offer, someone is making an offer to you, the supplier, you want to make sure that that is what you are looking at, that all the details are there in order for this to be an offer that could be that will be upheld in court if eventually you need to be involved in any court proceedings. Now there are also statements or actions that are not offers at the bottom of 212. So in the course of business, statements will be made or actions will occur which may look like offers, but which in law are not offers. Okay, and that's what we talked about, the 6 categories of invitation to treat, auctions, tenders, requests for information, statements of intention, and advertising puffs. So an advertising puff basically has no legal implications whatsoever. So imagine if someone, like Transformers, right? You've seen the Transformer movies. If someone has an ad of a car, say, and the car actually is acting like a transformer, it transforms into something else and then it goes back into a car and so on. That of course is not part of what you expect the car to do if you buy the car. It's just puff. So any reasonable person wouldn't expect that that's something that they will get if they go and buy this car. And that's what we mean by puff, and these things have no legal implications whatsoever. Now, when talking about invitation to treat, there's a very famous case on this called Pharmaceutical Society of Great Britain and Boots Cash Chemists. This is on page 213. So basically it says that an invitation to treat on top of the page is not an offer. It's not an offer, we know that already. And unlike an offer, why is it not an offer? It cannot be accepted. Okay, so it's not an offer because it's only an expression of a willingness to start the offer and acceptance process. So this is before even an offer is made, you see. So which in time may produce an offer and acceptance, but at this stage the party making an invitation to treat never intends to be bound. So the difference between an offer and an invitation to treat is that there's no intention to be bound. And if you go back again to the in brief box on page 211, we said the first thing about an offer, whether there was an intention or willingness to be bound. The main distinguishing feature between these two, offer and invitation to treat, is that an invitation to treat lacks or misses this component of intention or willingness to be bound. Yeah. Okay. So there are instances considered to be invitation to treat, and I'll leave that to you to have a look at, but also refer to something called Smith, S-M-Y-T-H-E, again on page 719, while you go through the readings here. Okay. And the point also to mention is that advertising of goods or services in newspapers or on radio, television, or the internet, again, the general rule is that advertising of goods or services in newspapers or on radio, television, or the internet should be regarded, as a general rule, should be regarded as an invitation to treat. There could still, however, of course, be exceptions. The business tip on page 215 says, care must be taken in the use of language or pricing by an offeror when promoting or selling their products or services. While it may be possible to avoid the consequences of the common law, businesses should be aware that a mistake, so if you advertise or you put the wrong price on a product, is not a defense to civil proceedings being taken for misleading and or deceptive conduct or misrepresentations about price under the ACL. Okay, so So these are things you have to be careful of and aware of as you carry out business or are working in a business environment. Now there's also another general rule in relation to price lists, circulars, and catalogs. This is on page 215. Again, as a general rule, price lists, circulars, and catalogs are considered to be invitation to treat. Again, there's no intention to be legally bound. Okay, so this is again recognition by the course of commercial reality and practicality. And you'll find that there is a risk management alert as well, that an offerer must take care in circulars, catalogs, advertisements, or even on the internet, okay, that the language they use does not show an intention to be legally bound or misleading, deceptive, or false. Because sometimes you'll find that a certain, for example, advertisement like the one in the Boots case, which is on page 213. There they found that that was not actually an invitation to treat, that was in fact an offer. But the key point is that it was an offer because it showed enough details to be legally bound. Okay, you'll have to read the summary of this case on page 113 and try to figure out what was really the key fact that the company did that made court believe that this was in fact an intention to be legally bound. Auctions, again, the advertisement of an auction is not an offer to hold it but an invitation to treat, and you've got some examples there. And there's this differentiation between auctions that are with reserve or auctions without reserve on page 116. So that basically means whether the seller has specified a minimum price under which they will not sell. Okay, so if I want to sell you a pen, I am saying to you, okay, I'll auction this pen, but I will not accept anything below $10. That's with reserve. Okay, so that would be an invitation to treat. Okay. Now, if it's without reserve, i.e., there's no minimum price set by the seller, he just wants or she just wants to sell a pen, that would be generally considered an invitation. That would be an offer. Okay, as it says on page 216, figure 8.3. So one more time, if an auction is with a reserve, i.e., with a minimum price, so you will not sell below $10, for example, that would be invitation to treat. However, if it's without reserve, so you are willing to sell at any price, that would more likely than not be considered an offer. However, read a little bit more on page 217, auction with no reserve. It says where the auction is held without reserve, there is no minimum price on what the goods are to sell for. The position is not so clear. Okay, so the position in Australia is that a vendor has the right to withdraw the property or to decline to accept a bid from a party at any time up until the fall of the hammer. Okay, so each bid is seen as representing an offer that could be accepted or rejected by the auctioneer. Alright. Then you'll also find that tenders are also invitations to treat, they are not offers. Okay, so you'll find that it says on page 217, to try to reinforce the view that the invitation to tender is not an offer, the party calling for tenders normally reserves the right to reject any and all tenders. Okay, at least definitely you'll find that a general practice is that they reserve the right to reject the lowest tender, the lowest price tender, because sometimes quality issues could stop them from doing so. Alright, again, risk management alert at the bottom of the page 217. Whether a tender is an offer or a conditional offer will depend on the exact wording used. Sometimes it would be an offer or a conditional offer. Okay, just like with anything else, it's the details that decide whether we can see all the elements of an offer or not. If it specifies exact needs, that would be an offer, or clearly indicate that the highest or lowest tenders will be accepted, that's again an offer, or what may be required. Okay, that's a conditional offer. So the key point is that it's really how much information you provide in these tenders or these auctions or these invitations to treat that could move it, because it's a question really of degree that you could move it from one of these categories into an offer. Alright, there's a question on page 218, top of the page, says, does an offer arise if a business invites tenders for the definite supply of goods or services over a certain period of time? The key point, of course, there is this definite. Okay, so it says if a company invites tender for supply of a definite quantity of goods over a given period of time, and the tender is made in response to that call for tenders, then that tender is an offer. It's an offer. Okay, so it's always again about how much is required for us to see that there is an intention to be bound. Okay, now whether acceptance results in a binding contract in such a situation depends on the language of the original tender to offer. And here there are two possible outcomes. The company may have stated its exact needs, so that will be of course an offer, or the company may have advertised only what it may require. Okay, so this is acceptance of this tender would create what is called a standing offer. Okay, there is no binding contract until a specific requisition for the material or the goods to the tender has been made. Okay, and the second situation here, again, we are always on page 218. It says the offeror can revoke their standing offer at any time, and they would not be liable, okay, for any further deliveries, although they would obviously be bound by any requisitions made prior to the revocation. Okay, I think that has been now covered. This is the option I talked about in relation to my example of selling you a pen for $10 and saying that I'll keep that offer open for you until you come back tomorrow morning and give that money to me, pay the price and take the pen. Okay, so let's then talk about how we can terminate an offer. There's more, of course, on pages 218 to 219 in relation to requests for information or things in relation to statements of intention. Okay, all of these I think we can leave for you to read. For example, in terms of statements of intention, note that says statements must be sufficiently detailed and comprehensive to achieve the requisite level of certainty in relation to essential matters to constitute a legally enforceable offer of a promise. So always remember, it's not clear-cut black and white. In law, it's always gray areas, right? And you are able to always argue that a statement of intention could in fact become okay, an offer, depending on how it was written, how it was stated, okay, and the level of details and level of certainty that would be in that statement. That's the key point, the key difference between law and any other thing you would ever study. There's no black and white. It's not like mathematics, it's not black and white. You can always argue things could move from one category on one situation to another. Okay. So we talked about some rules about offers, and we're gonna move on now. We talked about options only briefly, and the business tip again on page 221 is important. It says the use of an option supported by consideration by an offeree can prevent the offeror from revoking their offer for a specified period. The offeror has also agreed not to sell the item to anyone other than the offeree with that period. However, the offeror should specify in the option contract whether the offeree will recover their consideration if the option is not exercised. And we move on to page 222, where we start this third objective of termination of contract. And as you can see on page 8.4, we find that the termination could be done through a number of ways, including revocation of the offer, or rejection by the offeree, or a counter offer by the offeree, or due to lapse of time, and that of course depends on what's reasonable in circumstances, or the death of the offeror, or the failure of a condition. And the failure of a condition has three subcategories: subject to a condition, the offer is subject to condition, or subject to a condition precedent, i.e. before the contract is formed but after the agreement, or condition subsequent, i.e. after the contract is formed. Okay, and you can read more about these categories in relation to how we can terminate an offer. And when it comes to lapse of time, you would find that what happens if a business does not state how long an offer is to remain open. So this is when the risk management alert comes in, where no time has been specified for the acceptance of an offer. It must be accepted within a reasonable time. Okay, what's reasonable time will depend on what the offer is for. In the case of perishables, for example, the offer will remain open for only a short time. Perishables, things that will expire, for example, quickly, and they will be past their expired date quickly. So these things, of course, will have to be sold quickly as well. So you have to have reasonable time factoring in that fact. Okay. And then you have also some discussion on the lapse by death of either party. So it could be the offeror or the offeree, and there is a discussion there of how that impacts on the offer. So, for example, if the offeree learns of the offeror's death before acceptance of the offer, then a purported acceptance will be ineffective because the offer will have lapsed. But where the offeree is unaware of the death of the offeror, so the offeror made I made, for example, an offer to sell my pen to you for $10, then I died, but you don't know that I've died. Okay, in that situation, it's possible that a valid acceptance can be still binding and binds the offeror's estate, of course, not himself, because he's dead already, if the offer doesn't involve the personal involvement of the deceased offeror. So if there's nothing that the offeror has to do to execute this arrangement or the promises that were made, then it's feasible, it's possible that their estate, the people who will manage their fortune after their death, would actually be able still to accept your offer even though I am dead, or the person who made the offer is dead. Alright, let's look at the fourth objective then: explain acceptance and discuss its rules for an agreement to be binding. So this is now moving to the other side of the equation, if you like. Now we have looked at offer and all that needs to be satisfied for an offer to be legally binding, and now we're going to see what happens to the acceptance. Again, just like the offer, there's an in brief box on page 227 where it gives you the rules of acceptance. So it says if there is to be agreement, the acceptance must be made and relies on the offer. So of course that's just common sense. If you don't know that there is an offer, you wouldn't be able to make an acceptance. So this is the first rule out of the 7. The second one must be strictly in accordance with the terms of the offer. So if I say I want to sell something to you for this much money, for $10, that has to be paid today, you know, whatever else I specify, then you have to agree on all of that, to agree to all of that before we can say that there is a valid acceptance. If you question one of these things, or are not happy to go through with that kind of stipulation, then you have actually made a counter offer. So if I say, for example, to you, I will sell you this pen for $10, but you come and say, if I say to you, I will sell you this pen for $10, that you have to pay me now, and then you say to me, I will buy this pen for $10, but I will pay you the money tomorrow, that is actually not an acceptance. Okay, that is not an acceptance, because acceptance, as we said in the second rule, must be must be strictly in accordance with the terms of the offer. The terms here being that I want $10, but I want it also now. These are the terms that we're talking about. Okay. The third rule is that it must be communicated to the offeror orally, okay, in writing or by conduct. So you can either say, yes, I accept your offer, if the situation is just, you know, that I'm talking to you, or you could put it in writing, so we could agree that we will write something and you will sign it off as agreeing to those terms and conditions. or sometimes by conduct. For example, if someone goes out to find Fluffy and they find Fluffy and they come to you and say, give me the $10 that you have promised, that's their conduct. That's how they accepted your offer. They cannot be a cross offer. So if I make a counter offer or cross offer, that's not an acceptance. Or it can only be accepted by the party to whom the offer was made. Okay, can only be accepted by the party to whom the offer was made. I could make it to the world at large, and that means that anybody can accept this offer, but I can also make it only to you, then that makes you the only person who can accept that offer. Okay, the sixth rule is that it must be absolute and unqualified. Okay, so this actually sort of further gloss on what we said, that it has to be in strict accordance with the terms. The last one is that once made, once you have accepted, it cannot be revoked without the assent of the offeror. Unlike the offeror, who can revoke their offer, okay, within, of course, the stipulation that you cannot actually accept it. So before acceptance, the offeror has this flexibility of revoking the offer, of saying, I withdraw my offer, I cancel my offer. But if you make an acceptance, you can't have that. You can't actually go back and say, actually, I now want to cancel my offer. There's a 7-day cool-off period, where you can go back and say, actually, I've changed my mind sometimes. But generally speaking, you have the ability to actually revoke, and you can revoke your acceptance only if there's an assent by the offeror, and even if that assent was simply to have this cool-off period of 7 days. When we say cool-off period, we mean that within those 7 days you can actually revoke your acceptance. Alright, so this is what we were just talking about. So these 7 rules, okay, and there's further explanation of each one of these 7 rules on the following pages until page 231. Alright, so let's move on then to the last learning objective for today, and it says discuss acceptance under the poster rule, which starts on page 231, and compare it with the acceptance rules in instantaneous communications. Now, the poster rule is given to you in a business tip on page 231. It says where the parties contemplate the use of the post as a mode of delivery, but wish to avoid the operation of the poster rule, that is, so that the acceptance doesn't occur on posting the offer, on posting the acceptance by the offeree. The offeror may include a term in the offer to the effect that acceptance is only effective on receipt of notification of acceptance. So the whole idea behind the poster rule is that against business efficacy. So it says basically that if you receive an offer from someone by post, let's say, and you decide to accept that offer, so you receive my offer to sell you my pen for $10 by post. I send you this offer, would you like to buy this pen? I send you the photos, I send you everything, and you say yes, and you put that in writing in a letter, and you post the letter to me, say today. The poster rule says that your acceptance is effective today. You have accepted my offer today. Why is that? Not because you have written something and signed it, no, but because you have posted that to me today. And again, it's about business efficacy, so that you don't rather have to worry about whether someone else is going to buy it from me or not. You have basically certainty that you have actually bought this pen. That's how it works. So in order for you to know for sure that you have bought the pen, is that the minute that you put this acceptance in the post, then you know that you have effectively accepted and basically bought that pen. Okay. If on the other hand we have to wait for that letter to come to me, and we don't know how long it's going to take, and you don't know if it comes to me or I'm there or I receive it or not, that creates uncertainty. That would be not optimal or conductive for business. So this is why the rationale behind this poster rule. Now remember that the poster rule is not going to be applicable when you use electronic communications or instantaneous communications. Let's just rehash quickly. It says the postal rule: an offer made by letter is not effective until it is received by the offeree. You get that? The offer is not effective until received by the offeree. Again, common sense, because how would I know that there's an offer before I receive it? But the postal rule really says that acceptance is effective as soon as it is posted. You don't have to wait for the offeror to receive your acceptance for it to be posted. So it's asymmetric in a sense. So for the offer, it has to be received. For acceptance, it has to be posted for it to be effective. And again, revocation of offer must be received by the offeree before they post their acceptance. So withdrawal of acceptance by post: Australian postal regulations enable recovery of letters, and there's something called the National Consumer Credit Protection Act of 2009 that says that modifies this postal rule by statutory modification. So it says once the offeree has accepted an offer, okay, the agreement is binding unless the parties agree to release each other. Okay. So that's the point that is mentioned as well in your textbook in relation to the postal rule and withdrawal of acceptance by post. On page 234, it says the National Credit Code is a statutory modification to the General Postal Rule, Schedule 1, Section 196, Subsection 1, Paragraph B of the National Consumer Credit Protection Act of 2009. The Commonwealth provides that a document sent by post that is that's related to consumer credit will be considered. Here's the thing. A document sent by post that is related to a consumer credit will be considered to be given on the date when it would have been delivered in the ordinary course of post. Okay, so once the offeree has accepted the offer, the agreement is binding on the parties unless they agree to release each other. So this is the modification that came out from this legislation in relation to the postal rule. Okay, so it says again, a document sent by post that's related to consumer credit will be considered to be given on the date when it would have been delivered in the ordinary course of post. So given when delivered. Okay. Now the last thing I want to talk about is instantaneous communications. The key point here is that the postal rules do not apply, and it should be clear why not, because there is no delay between the time you accept or post and the time that the other person receives your reply, because it's instantaneous. So the contract here again is formed when acceptance is received. You have to wait for it to be received. Okay. Compare email and internet with fax and telex. So the idea that email is even faster. So here the postal rule wouldn't apply. Offer is effective when received, and acceptance is effective when received. So there's more symmetry now. Okay. There's also a UN Convention on the use of electronic communications in international contracts. This is from 2005, and Australia adopted this convention, and you can see the effect of that in the Electronic Transactions Amendment Act of 2011. So again, the key point again is that this is in relation to enabling or enhancing legal certainty and commercial probability. Alright, so that's what we have for today. The last thing maybe just quickly is to talk about the business tip on page 235. It says to minimize problems with contract formation where the method of transaction is email or the internet, the person controlling the transaction should make it clear that what is to be taken as an offer or what is required for an acceptance. So again, you have to make clear, the person controlling the transaction, for example, your website, you should make it clear what is to be taken as an offer or what is required for acceptance, and when electronic communications are to take effect, and include a choice of jurisdiction clause. Okay, include a choice of jurisdiction clause, meaning that should a dispute arise between you and the parties that are making the transaction or buying from you, which jurisdiction should deal with that matter, because your buyers could come from anywhere in the world. So they need to know, and you need to make certain that it's going to, for example, Australian law that will apply if there is any matter or dispute that ends in the courts. Alright, so that's the end of our lecture for today, and for tomorrow we are going to continue for the next recording. We're going to continue with chapter 9 and continue with our substantive area of contracts, and we will look at the second element for the existence of a contract, so namely the intention to create legal relations, and that's going to be our next recording. Bye for now.